Hello, everyone. Welcome to the arbitration channel. Today, we're gonna play the last episode of the season Aparte da Parte. Aparte da Parte is a client perspective program we did in Brazil, focus in the arbitration in the perspective of the general counsel about arbitration. This last one is most and special because we're gonna have Rick Sinkfield from Laureate Group, Nilufar Hossain from Omni Bridgeway, and of course, Andre Luis Monteiro from the Quinn Emanuel, our host and coordinator from our first season. We want to thank you, the Omni Bridgeway and Quinn Emanuel, to be the supporters of this initiative. Andre, welcome.
Thank you very much, Lauro, for the kind introduction. It's a great pleasure for me to talk to your audience today and to talk to Rick and Nullifor. So let's go straight to the first question, Rick. And the first one is a pretty basic one. We just want to know about your career, more about your experience. So can you please, Rick, tell us a little bit about your career and how did you discover arbitration for the first time? How was this experience? Tell me a little bit about you.
And thank you, Arbitration Channel. It's a pleasure to be here. In terms of my career, I started off right out of law school. I went to work for the State Department, the U.S. State Department. And believe it or not, that was actually my first experience with arbitration. I represented the United States as part of the federal team in the Iran-U.S. Claims Tribunal, which of course I think is probably the longest reigning, lasting arbitration in the world, actually, going back to 1979, 1980. And so that was my first experience. And then, of course, I continued to work for the federal government, went into the private practice, and that's where I really learned and started working in what we think of as modern arbitration versus public to private or public arbitration. And, as you know, 30 years ago, arbitration was really first coming to in its own as a direct response to concerns, particularly in the private sector, about delays, unfairness, and inequality in the in the judicial system, the normal judicial system, particularly leaving what we call the Western countries, right? So as international business expanded, there was concerns about the quality of judiciary systems and justice systems in lots of different countries, and frankly, even in the U.S. And so arbitration grew. It grew very strong. And so as arbitration was growing, my career was growing. And so it was a very natural place to be interested in what was then generally called alternative dispute resolution, or ADR. And so that's kind of where I was, both in the private sector and everything from railway arbitrations to employment arbitrations to international business disputes, particularly as I joined a company, Laureate, that was very, very active in growing across the world and would ultimately end up in 30 countries. And so you can imagine when you've got operations in 30 countries, the desire to have some semblance of consistency in your business affairs required a deference to, or a preference really, for arbitration. And again, seeking, because we tended to have similar deals, similar clauses, and the ideal was to, if we ever got into disputes, to try to have some consistency around our business practices. So that's really kind of what's brought me to today.
Thank you, Rick. Yeah, it's very interesting. You mentioned neutrality as one of the features of arbitration, and definitely it is very important when you, in particular for companies that are working on different countries. Yes, so it's quite hard to understand the particularities of each place. So if you go to arbitration, I think it's quite a safe place to be if you are working and operating in different countries. So let me go to the next question, which is about your day. So your day-to-day How does your day-to-day look like? What sort of matters do you deal with every day at your group?
As a chief legal officer, and I'm also the chief ethics and compliance officer, what I find is, and I don't know if this is true for most companies, but we operate universities. And so on a university campus or in a university setting, whether it's online or offline, we deal with the same things that our students deal with every day. And that can be everything from sickness, crime, economic issues, protests, tax authorities, building authority. I mean, basically, I always tell people that being the head of a education company, as we are, is kind of like being the mayor or the general counsel for a city. Everything that goes on in your city goes on with us someplace around the world. So I never know what's going to happen on any given day. I have a calendar where I think I know what I'm going to do. And then at some point, I'm going to get an email or a call, and I've got to decide whether I need to jump to that or whether I can stay on point and stick to the way my day is supposed to go. So we see everything, we really do. But I think that also makes the job very interesting because we're never bored. There's no sense of repetition here ever. And also because we were in so many countries and in different markets, we have to be creative. And we like to say, there's problems and there's laureate problems, which is another way of saying the level of complexity that we find in our business is very high. And so that's very challenging, both professionally and, academically, intellectually, if you will.
Great. Thanks so much, Rick. It sounds like a fascinating role that you have. I wanted to go back a little bit to you had mentioned that you started your career with the U.S. Iran's Claims Tribunal. And so obviously you have a great foundation in international arbitration. I'd love to hear a little bit more about your role today and whether it's more focused on international arbitration or domestic arbitration or just anything in general, like how arbitration relates to what work you're doing now in the private sector.
We went through an interesting phase where we divested numerically 90% of our businesses, but only 50% of our businesses in terms of student base. So we're now focused in 2 countries. We still have arbitrations from those divestitures, so I still focus on those. And we have current arbitrations with our current operations. Fortunately, because we don't have partners anymore, those tended to be the most complex arbitrations. The arbitrations around transactions and trying to understand, quote, what the parties really meant. And as you know, an arbitration is a dispute. And so whenever you get into those disputes, typically what we found was that the arbitrations tend to come from those parts of the negotiation where there was the least amount of agreement. There was an agreement, but as time moved on, different expectations of the parties either weren't met or perhaps their intention all along was to wait and revisit the issue in the context of a dispute instead of in the context of signing an agreement. And that happens. So that's always been my experience on the business, the B2B side. On the B to employee or the B to customer side, typical commercial disputes or employment disputes. It's a one-off kind of thing. And those sometimes are actually tougher to deal with because I think there's more emotion involved. And usually it's local law that's involved. And so sometimes our ability to manage those is more restricted.
That's very interesting. So could you generalize a little bit in terms of the kinds, given the vast types of disputes that you've worked with and that you routinely see, are there certain ones that in your mind think, okay, this would be great to have an arbitration clause should this transaction end up in a dispute, and are there others that you know off the bat we wouldn't include an arbitration clause in this transaction?
Look, there's not a transaction that we're going to do where we're not going to include an arbitration clause. and again, that goes back to something that Andre pointed out earlier, and we were talking about kind of the history of arbitration. It really goes to what you want is you want speed, expertise, and some certainty that the outcome is going to be a fair outcome. And when I say fair, I mean tending to follow the law, right? You can never rule out other factors completely, but certainly in an arbitration, you're expecting to get more expert, more objective dispute arbiters who are really going to treat both sides fairly and not lean in because one party is a local business magnate or something like that. And that's always our concern, is that if you have a dispute, particularly as an American company or as an international company, there's a belief either that every American company has deep pockets, and so, what's the big deal? They're just asking for, $10 million more, pay the guy, right? I mean, we have that. We have people say that, why shouldn't you pay me? You're a rich company. You can afford this. I mean, I can't tell you how many times I've heard that from people on counterparties, as if we're a bank. And we always said, look, we're not a bank. We're a business. And so, but we find in some judicial systems, and sometimes even some arbitrators may have the same attitude, So that's really why we prefer arbitration, is we try to get people who will limit their biases outside of the transaction or outside of the dispute and only focus on what the parties are saying and what they sign. That's our goal. That's our hope.
Okay. Yeah, I would like to explore a little bit more this point, Rick, because you're saying that depending on your investment, you're concerned about particularity of the local and how they would see an American firm in a fight there. So I think I would like to explore a little bit more. And in arbitration, you can choose basically two very important things, which is the seat of the arbitration and the applicable law. So what's your perspective? I know that you know Brazil very well and you speak Portuguese better than me. and so if imagine you need to make an investment in Brazil, you're dealing with an investment made in Brazil. So would you choose the seat there? Would you choose the Brazilian law as an applicable law? Would you choose a different one? How do you deal with these questions in a case?
Yeah, listen, I think that choosing the seat in Brazil is fine. People have different views. I'm fine with it for one reason only. Is the bar in Brazil, particularly the arbitration bar and the mediation bar, has become extremely expert and professionalized over the last 20 years. I don't remember the exact date of the arbitration law in Brazil. You may know it off the top of your head, but I remember my first arbitration in Brazil. We ended up bringing one of the first cases challenging an arbitration ruling on constitutional grounds. It was a very procedural ground, and there was no doubt they had violated the Constitution. So, as you know, overturning an arbitration order is difficult, and there are only two grounds, right? Constitutionality and public policy. So, and we won that case. And so I got a chance, again, at the beginning of Brazilian arbitration law, to watch the growth of the arbitration bar. So I think the quality of Brazilian arbitrators is very high. You've got several tribunals, whether it's COM or ICC, there's various sophisticated tribunals there who can handle big time arbitrations. I think the issue, of course, is finding the right arbitrator or the right three arbitrators, simply because Brazil has so many businesses and disputes that we know that some of the arbitrators that you want or need are just so busy. And then that raises a problem about speed of arbitration, right? One of the main reasons you want to arbitrate is because you think that you can get this dispute discussed, decided, and move on. Because as you know, the Brazilian judicial system can take 5, 10, even 20 years. In which case, how do you run a business when the dispute is not going to get settled for 20 years? You know, that's kind of unconscionable. So I know that's a long answer, but again, no, you know, and for law, actually, let me address that. For the choice of law, Brazilian law is tough because A, it's civil code, and B, the civil code in Brazil hasn't kept pace with developments in commercial relationships. It just hasn't. And so there's things that you can do commercially to agree, but they may or may not be well situated in Brazilian law, in which case the original intent of the parties may not be reflected in legal protections. And we've had that happen to us before, where there's no doubt the parties agreed on something. And when it was disputed, one of the parties was able to point to an anomaly in Brazilian law to basically voided the agreement between the parties. And that really shouldn't happen, right? It really shouldn't happen. So I would always try to choose New York law, Delaware law, you know, UK law, laws where the commercial sophistication of the law is more advanced and closer to the commercial sophistication of the parties.
That leads to a related question in my mind, given the importance of the law, the choice of law clause, and so forth, and the seat. What are the main features you're looking for in an arbitrator? Are there specific arbitrators or skill sets that you're looking for particular types of disputes or particular regions and so forth?
Yeah, that's a great question, Nilufar. You know, first off, we're always probably going to have to defer and depend on the views of our counsel, our arbitration counsel, because they operate in this space more than we do. So what we really want is a good reputation for fairness, a reputation for openness, right? And in that, we can do research. So depending on what kind of dispute we have, we may want someone who is well versed and well known in an area, right? They've written 16 different treatises in a book on the issue that we are trying to litigate. But most of the times we probably want someone who hasn't written that much, because you kind of already know what they think. And so it just depends on the case, but certainly, you know, we will go to experts and get their opinion, even if we don't use them as the arbitrator, right? And sometimes in talking to experts, we'll get recommendations on people that they think are knowledgeable, but still open to argumentation, right? Especially on those interpretive questions, conflict of laws, you know, civil procedure, things like that. You really want to try to get someone who's open to listening to your argument.
That makes a lot of sense, and that's helpful to know. On a related note, how about the availability of the arbitrator? As you know, in international arbitration, certain arbitrators are in more demand than in others, but of course that results in lengthier times to getting to a final award, and scheduling, you know, very challenging scheduling difficulties between hearings and submissions and so forth. How much of that comes into play for you, you know, looking at your global portfolio of disputes?
No, look, the age-old saying, you know, justice delayed is justice denied. It applies to everything, and I think, you know, it's weird because sometimes, depending on where you are in the dispute, you want to delay things, right? So I'm not going to say that delay is always bad, because sometimes I may want to delay things. But what we know is delay is going to probably confer an advantage on one of the parties. And so if you think about this objectively, as an arbitrator, you should never knowingly or even indirectly try to put yourself in the position that automatically advantages one party or another. So I think that's why timeliness, set a calendar and stick to it, right? And this way you're putting pressure on the parties equally. That's our goal. So in that respect, if I know an arbitrator is really well known, but has a really long calendar and is known for delays, I probably don't want to use that arbitrator. Because, and even in reality, even if I think I am benefiting by some delay, that may not always last during the course of the proceedings. And, again, I have a dispute. So if I'm going to lose that dispute, maybe I want to lose sooner rather than later. So again, I just think you set a calendar, you stick to it, and then the parties over the course of that proceeding can decide whether to settle on their own or whether to deal with the arbitrator, because the business is still ongoing. I think that's the one thing that we miss in arbitration is it's not in a vacuum. There's a business that's happening and there's an arbitration that's happening that's trying to help the business continue to operating. So the sooner the business operates on whatever plane it's going to operate on, generally the better.
Thank you, Rick. I quite like your answer about the Brazilian law and your experience that you had 2 years ago, and you were saying that actually commercial parties, yes, prefer a system that respect what is in the contract. Yes, because in this case, you don't have surprises based on statutory provisions that actually nobody thought about when they were
That's right.
writing the contract. I mean, just to respect the bargain. I think it's very interesting coming from you. So I heard your other answers, and I'm curious about Brazil, how to apply your last answers to the Brazilian community. So it's commonplace now to say that in Brazil the pool of arbitrators is too small, and I heard you saying about arbitrators with less availability and means that actually they are not available and the arbitration will take more time than it should. I mean, how do you see this in not only the problem of the speed of the arbitration, but maybe other problems related to a small pool of arbitrators, but also, and this is sort of more a challenge than a question. So how can clients help with this issue?
Wow. Well, first off, I think there's 2 reasons why the pool is small. And it is what I'll call organizational behavior. And you see it, I'm going to make a strange analogy, but you see it in coaching, you see it in how people hire CEOs, you see it so at some point the community gets focused on a very familiar common group of people, and there's a fear or hesitation to go outside of that pool, period. That's the main reason why we have that issue in Brazil. There's an unwillingness of lawyers, and there's a distrust of clients just to use other arbitrators who are probably perfectly competent. So I think that what the arbitrator community and the clients can do is force and request that there be a process, more formalized process, where other newer arbitrators can be certified or classified as people saying, yes, these people are good people, let's try to start using them, and not have it be so dependent on counsel picking the people who they're familiar with and they know because they've had 17 arbitrations with them. And by the way, that doesn't make them biased, right? I don't want to suggest that, but that familiarity, they need to be familiar and comfortable with the wider pool. And the only way that's going to happen is if it's forced, right? So that's the way to address that. And then beyond that, I think it's a good thing that there's people who everybody recognizes as being great arbitrators. I think that those great arbitrators can also help by conferring some credibility to other arbitrators who they know and trust and or have trained, right, or have worked with in an arbitration. If you have an arbitration panel with 3 people, and by the way, I've been on not an arbitration panel, but when I was an ethics expert for the bar, we sit on ethics panels. It's 3 people, a chair, 2 other lawyers, and we hear ethics cases. So that it's the same setup as an arbitral panel, right? After you work with someone on an ethics case or an arbitral case, whether they're good, whether you kind of know that. We have a duty amongst ourselves to recommend other people that we've seen up close, who we know are good professionals, so that when you're too busy, you say, listen, I have 50 cases or however many cases I have. I just worked on this arbitration with Nilufar. She's a great lawyer. I don't know what her schedule is, but you should call her, right? That's the way, a safe way, I think, to expand the pool. And then I also think that we have a duty to make the pool more diverse. Women, minorities, people who went to other law schools in the law school that we went to. I mean, it's not like there's a monopoly on people who went to USP, right? Why? I mean, it's not that those aren't the only great arbitrators. So I think that we can, if we're conscious about expanding the pool and we base it on competence, the system will work better for everybody.
Yep. No, that's absolutely great. So let's. I mean, we discussed a couple of things about arbitrators, and maybe I think in my own interest, maybe we can move to discuss lawyers. I think it would be very helpful, not only to me, but to a lot of friends. So that's the question. So what are the main attributes? I mean, the main characteristics you look for in a lawyer when you have an arbitration case. So should this person have experience in arbitration? Should this person have a deep knowledge about the applicable law? So what actually you look for?
So I'm a big fan of teams, right? Team player, team concept. And so I envision myself when I go into an arbitration as both a coach and a manager. And let me divide those two. So as a coach, right, your responsibility is to get the most out of your players, period. You have an objective to win or whatever. How do you do that? You get the most out of your players. And that involves, to some extent, training. And that also involves, what I'd call in-game adjustments, right? You set a strategy, you set a plan. The other side has a strategy and plan. And as you're playing it out, your ability to win is based on your ability to adjust to what you're seeing as the game is going by. As a manager, and this goes to your first point about lawyers, your job is to get the best talent onto the team. So when I go to think about lawyers, absolutely, I want someone with deep arbitration experience or deep experience in some part that's going to be critical to winning. Because maybe my chief lawyer isn't the arbitrator, maybe my chief lawyer is the corporate lawyer, and then I get an arbitrator who works well with my chief corporate lawyer, and they are my team, right? So I've got both, theoretically, both sides covered. And then as the coach, my job then becomes to get the most out of those two lawyers and drive them, support them to a winning strategy, right? That tends to be the way I approach these things. And from a perspective, it's really important that my lawyers understand my business objective, and not lose sight of that, right? I think as lawyers, particularly in private practice, we see our mission as winning, right? Even if it takes 3 years or 5 years or whatever, and no expense is too big to win, right? But I think as outside counsel, you always have to really be very close to what's happening with the client's business and how is this litigation, how is this arbitration affecting the client's business. And I think the last thing, and this is a personal quality, is, I like people who are self-aware. That doesn't mean that they're humble. It doesn't mean that they're arrogant. It doesn't mean that you could be any of those things, but I need you to be self-aware, because effectively, once you become my lawyer, you're representing me. You're representing the company. And so how you're perceived and how you interact with the other side, with our internal clients, is a reflection of the company, and it's a reflection of me. So that's very important. I need people who understand that, and understand that they're not the star, right? I'm not even the star. The matter is the star, and we're all working towards getting this matter resolved.
That's very interesting, fascinating. I've never heard this explanation before. This last part of the explanation, that you look at the lawyer, you don't want to star, you want someone that's part of your team, because you are, all the same team. So I think that's a fascinating explanation, and I think there are a lot of lawyers that should listen to what you just said. Okay, but let's talk about another very interesting part, maybe not for clients, but for lawyers, which is fees. So we know that, in general, you have two systems. Yes, basically, we have the English rule, where the cost follows the event, and if you lose the case, you need to pay the fees of the other party. We have the American rule, which each party bears its own costs. And we have something different, at least not in arbitration, but at least before the courts in Brazil, which is this rule that if you lose the case, you need to pay from 10 to 20% of the claim value to the lawyer of the other party. So how do you see this, legal fees difference between assistants? What is the best one for you? So what would you advise a lawyer when you're discussing fees with you?
It's funny. I remember the first time I had a case where under the Brazilians, I'll go backwards. I remember my first time having a case where we had to pay 10 to 20% of the lawyer to the lawyer in a Brazil case. And I was horrified. I really was. And I think that all these pay systems, you have to think of it in terms of what's the incentive, right? Are we incentivizing just more litigation? Are we incentivizing people to fight longer over nothing because they want to get their fees? I mean, to me, that's the problem. So I tend to think, and maybe I'm American, maybe I'm biased, but I tend to think that in general, having to pay for your own fees aligns the incentives, and it forces parties to constantly be rational about whether they want to continue or how hard they want to fight. And actually, I think that's where, I think it did such a good job that we see two things offshoot from that. One, the plaintiff's bar that says, look, people who can't afford to pay lawyers shouldn't be barred from pursuing a case because they can't afford their lawyers. I agree with that. Similarly, the second offshoot from that is even people who can afford their lawyers, maybe it's just not worth it to pay them. So then we have third parties come in and we'll say, well, actually, it's worth it to me to pay them. And let's just rearrange the potential outcome for winning. So I think that those two systems, well, that system and the two offshoots probably makes the most sense because, again, you're constantly forcing parties to assess the merits of the case and the cost benefits of continuing to fight. Every system that is ripe for abuse, right? And depending on the case. But I think if you just put that down across the board, I think that one works the best.
That's really interesting. Thank you for sharing those views, Rick. If you don't mind, I'd love to go back to a couple of the points you had raised earlier. As you know, one of the issues that a lot of people discuss in arbitration these days is increasing diversity. And you had helpfully discussed the size of the Brazilian arbitration pool and how we could increase that. Also, just looking at people who don't go to the same set of schools and so forth. It would be great to hear your views as to what matters in terms of diversity in arbitration. What sort of diversity are you considering? Is it gender? Is it race, sexuality, socioeconomics, and so forth? Thank you.
Yeah, listen, so in terms of preference, there's no preference for me. As full disclosure, I've been involved in Brazil for a number of years with an effort to increase the number of Black Brazilians in the bar, particularly in the international bar in Brazil. Why? Because in 20 years of working there, I think I've probably run across, and maybe it's a little bit more, but a little bit less, but the fact that I can count it on one hand is pathetic, right? That's just inexcusable. It's historical. There's a reason for it, but that doesn't mean that we have to be satisfied with that as a fact. So that's where my effort has been. But I'm very proud of the fact that on my teams, since the day I came to Brazil, I've had any number of lead women on my teams, and that I think every one of them is now a partner in, if not the original law firm, other law firms. And so I'd like to think, I hope they'd agree with me, that their work with us and their work with me helped form and make them better lawyers so that they were then ready to become partners in other law firms or their firms. That's very important to me. As arbitrators, look, it starts with the team, right? So you have to have a team, the junior lawyers, the mid-level lawyers, that reflects diversity, and that may require you bringing someone onto your team that you didn't always have. Well, how else are they going to get experience if you don't bring them on the team, right? And that I just don't think, I think that's a small gesture. It's an easy thing to do. It may get out of your comfort zone, but of course you want to do it. It's for the betterment of the profession. In terms of other priorities, I think the toughest one is sexuality, sexual orientation. I never presume anybody's sexual orientation. If they say to me, I'm part of the LGBTQ plus community, great. You're welcome on my team, period. If I know someone is part of that, then I'm, again, happy to bring them on. The others are more visual, and so it's kind of obvious. So it's easier without having to ask someone, what's your sexual orientation? So yeah, we're an open team, period. And if you want to be on the team and you have something to offer, we can work with that. That's the way I approach it.
Yeah, thank you, Rick. I think you mentioned something very interesting. So you said there's no difference between the minorities. We of course need to look after all of them and try to improve their chances. But some of them are more visual, which makes things in practice harder for the ones who are not visual. And I think about, you mentioned
That's right.
You mentioned sexual orientation, and also the economic background. So it's not
Yes.
visual at all. So I mean,
Correct.
it's really hard in practice to trying to solve this problem if you're not seeing it. So it's a very interesting perspective. Thank you for raising this point. So I will.
But I think, Andre, and I think
Go ahead.
that's from the client's perspective. There are proxies. For instance, in Brazil, we know that socioeconomically, Black Brazilians, Afro Brazilians are disproportionately skewed to the lower socioeconomic classes. So I can almost, by closing my eyes, right? If I pick someone and I focus on Black Brazilian lawyers, I'm probably going to pick up the socioeconomic diversity, right off the bat. I can also probably find out if the person is already fluent in English, then they probably are from a higher socioeconomic class, right? So if I can quickly find that out, right, if I ask the right questions. And to me, English is a perfect example of getting past easy barriers. There is no correlation between intelligence, competence, and language fluency. Zero. It's been proven over and over and over again. We make a mistake in assuming that because someone can express themselves in multiple languages, that they're smart. That's just not true. It's just not true. There's lots of really smart people who would be just as smart in foreign languages if we take the time to teach them the foreign language. And so we realize that in our efforts with Black Brazilian lawyers, take a year or two to learn English and have people pay for it. And suddenly the same brilliant lawyer who didn't seem as smart because, or desirable because they couldn't express themselves in 3 languages, now they're desirable because they have the skills, right? So English is a skill. It is not a sign of intelligence or subject matter competence. We have to think differently about that. Similarly, when it comes to gender, I had a person on my team who wanted to have kids, right? And so, super competent lawyer, and she was talking to me about her tension about whether she wanted to have kids and how she would be perceived by her colleagues as not being as hard of a worker when she was working from home. But this is pre-COVID, of course, because she was working from home, taking care of her kids and working on my deal, right? Perception, if you're not working in the office, you're not that hard of a worker. Response, no, she's working harder than everybody in the office because she's taking care of a newborn and she's still meeting all of the deadlines for this deal. No, I don't want to say who's the harder worker, but clearly she's having to work more, even if half of it is at home with the kid. I mean, those are the kinds of things where we have to open our minds and say, why are we discriminating or disadvantaging people based on outdated and wrong assumptions about how people work and how smart they are, right? So for me, my role is to call attention and say, hey, wait a minute, that's not right. Of course she's still working hard, right? Of course she is. Keep her on the team. Or we'll find somebody when she's on maternity leave, but as soon as she comes back, she's back on the team, right? I don't think that's that hard to do.
Yeah, before Nilufar asks the next question, I just want to recommend something to Laura Parenti. Laura, I think you should invite Rick for a specific episode just to discuss diversity, because I've heard a lot of good and new ideas that I didn't hear before. I think Laura, so take note and invite him for a specific episode to discuss it. Yeah.
I would love to.
No, I agree with Andre. It's been a fascinating discussion on that. And Rick, I appreciate your perspective because, as you know, in America we have one kind of set of views on diversity, and then when you take those views globally and see how they impact the reality on the ground in other countries, whether it's Brazil or elsewhere in Latin America or just globally, it's quite a different scenario. I've enjoyed hearing your perspectives on this. And so if you don't mind, just to wrap it up, if we could change topics to something that's near and dear to me, which is Third-party funding.
Absolutely. Glad to.
As you know, Omni Bridgeway is one of the largest global litigation risk managers. We are a company that has offices in 23 countries around the globe, and we are committed to helping to finance justice for our clients, whether they are the lawyers that represent them or they're the clients themselves. I'd love to hear, given the global footprint of your company, how experienced you are with third-party funding. Have you used it, and any thoughts on it in general would be great. No,
thank you for the opportunity. We've considered using third-party funding, and we're considering third-party funding right now for a few cases. And it goes back to economics. It goes back to time and focus, right? For us, the cases that we consider for third-party funding are what I would call our peripheral cases. In other words, they're cases that we think are probably meritorious, have a pretty big upside, but are no longer central to our main business. So we have a decision to make. Pursue it with a big upside, but you could always lose, right? Or just not pursue it at all and feel kind of guilty that we stopped pursuing it because even though the upside was good, it's not our focus. And so we don't want to spend the money because we'd rather spend that money on something that's our focus. That tends to be our perspective. If it's a main case that's central to our business, we're going to fund it, right? And we want to control it. So for us, cases we think we're going to win more than 50-50, large enough upside, and particularly there because we know if we bring in a third-party funder, at that point we're sharing the upside, right? So the gain has to be big enough where we're sharing the upside. And I'll tell you, there's one kind of case that usually fits that bill, and it's insurance cases, right? Where the insurers, as you know, I imagine a lot of your portfolio involves either insurance on the side or against insurers that have picked up a claim from an insured. The insurers don't want to pay. They never want to pay, right? And in the business world, where you have multiple layers of insurance, because you have to have multiple layers of insurance, then that area gets even more complicated. And so one of the things that we find in talking to third-party insurers is if a third-party funder is interested in our case, it's probably because they have experience, more experience than we do. And if they say to us, yeah, we'll take that case, then it's because they think they're going to make money. Now, they may be wrong, but if they think they're going to make money on it, that makes us feel even better about the fact that we think there's a case there. And so in that case, we're more inclined to have a partnership. I don't know where these cases are going to go, but like I said, there's one that I'm thinking about right now. It's got like I think the policy limit is $10 million. We think it's like a $20 million case. So we know the case is worth more than the policy limit. But that's one where we may want to bring in a third-party funder because the insurance company is telling us that it's, $100,000 case. We know that's total nonsense, but maybe I've got to spend $1.5 million for 2 or 3 years, 2.5 years to bring it to term. It's perfect. It's a perfect scenario for a third-party funder, at least the conversation. That's great. That's great to hear. So in your experience to date, or just what you've heard about third-party funding, because there's a lot that's said about third-party funders, what kind of concerns do you have in terms of entering into a funding agreement and working with a funder? A lot of times what we hear on the funding side is people don't like to lose control. They have this perception that the funder is going to control everything, which I'd like to dispel that myth that that's not true at all. We view ourselves as a partner alongside the client and alongside their lawyers. But I'd love to hear from you just how this has evolved in your mind and some of the concerns that you may have experienced or have had moving forward. Sure. No, look, I think it's funny. I'll push you a little bit. I think that the concern about control is a legitimate concern, but from the other side, actually. In other words, when I'm dealing with a plaintiff or a counterparty where there's a third-party funder involved, there is a tension, there is a conflict, again, in resolving the issue. So the third-party funder is not in the business that my counterparty is in. And so I have seen tension between the third-party funder having a view of how much this case should be that is a little different from the counterparty, who wants to get out of the business or wants to continue business or whatever the case is. So I've had a more difficult time with third-party funders trying to settle cases when they're on the other side. Again, not on my side. I don't know how you resolve that. I think it comes in the form of how the third-party funding agreement is drawn and drafted. And I know that different funders like to use different standards, So from my perspective as a client, I'm going to try to negotiate enough autonomy that when I make the decision about when it's time to stop or when it's time to settle, et cetera, I make that decision based on my business and not truly an economic concern. I think that's the tough part. But again, I think that's a one-on-one negotiation and a knowledge of the matter. So I think so long as the third-party funders are willing to give up that control and maybe have some kind of balance in the economics, then maybe it'll work. But I don't presume to have an answer for that.
It's very interesting to hear your views. It sounds like you've worked with a number of different funders over the course of your career. Could you speak just a little bit about maybe some of the best practices that you've seen or what your likes or dislikes are with respect to working with funders?
I think the question is who's doing the negotiating? I've seen it where the third party funder does, basically his bargain for the right to come to the negotiating table with me on the other side. I tend to find that problematic because I find that they're not as steeped in the details of the case as I'd like, in which case it makes it hard to have a conversation. That's been my experience. So I think a best practice really is, to be clear on who's calling the shots, right? Because at the same time, I've had parties. So, I hear one thing from the neutral party, and then I'm hearing something else from the third party funder. As the counterparty, I'm like, wait a minute, you guys got to get on the same page, So I think that's probably the most important thing from a counterparty perspective. And again, in terms of the agreement, if you're on the third party funding side, I think clarity about decision making, clarity about, really how the upside is, and clarity about, which lawyers are calling what shots. I think that's critical. Otherwise, you just make a mess. You have the potential to make a mess out of something that's already messy.
Okay. Well, I enjoyed this discussion very much. I heard things that I didn't hear before. Learned a lot from you both. Unfortunately, Laura told me that we cannot go over 55 minutes. We need to stop. There is a hard stop at 55 minutes. So I want to say thank you very much, Sharik
Thank you.
and Nilufar, for your time, for the help of for helping with the questions, for the answers. I will give you 30 seconds if you want to leave a final closing message. So please, Rick first and then Nilufar.
Look, my final message is just to thank both of you. I love the opportunity to have these conversations, to meet old friends, meet new friends, and I expect our paths will continue to cross. And so, Lauro, I've known him for years now, and I love the opportunity to share these thoughts and to grow with each other. So I really appreciate it. Thank you.
Thank you, Rick, and thank you, Andre. I found this to be a very interesting discussion, so I appreciate having been invited to speak with you today. Thank you to Lauro and the Arbitration Channel team for organizing this. I look forward to finding other opportunities to work with Andre, with Rick, with Arbitration Channel, and of course anyone who's listening and might be interested in learning more about third-party funding. I'm easily reachable. But thank you again for your time. Thank you for your interesting thoughts. Have a great day.
Thank you.
Bye-bye.